We're here today to remember the 50 Michigan women who are killed every year by abusers with a firearm. That's nearly one woman per week. We're also remembering the 20 children who are killed each year by domestic abuse. The 70 empty pairs of shoes on the Capitol steps before us represent families that have been torn apart. Children who've lost a parent, parents who have lost children, and dreams that have been shattered. Each pair of shoes, each life, represents a failure by us as a society to protect survivors of domestic violence. These women should be walking to their jobs, to school, to kids' birthday parties. These children should have just put on a new outfit to start the school year. Instead, their futures have been stolen from them, and their loved ones are desperately holding on to their memories. Amber Jo Thomas was in an abusive relationship for 9 years, enduring horrible physical and verbal abuse. She was finally able to leave, and she requested a PPO a week before she was murdered by her ex while on a break from work, where she and an acquaintance were ambushed by her ex. A day later, Andrika McIntosh, a mother of 7 in Detroit, was murdered by her husband of 13 years, gunned down in her driveway. It was the morning of their divorce hearing. Lastly, Maggie Wardle, a sophomore at Kalamazoo College in 1999, was murdered by her ex-boyfriend because, according to her parents, Rick and Martha O'Million, if he couldn't have her, no one could. After he killed Precious Maggie, he took his own life with the gun. These women were all trying to leave, and that can be the moment when abusers are the most dangerous. It doesn't have to be this way. Abusers have proven that they're too dangerous to have guns by being violent towards those that are supposed to love, those that they are supposed to love and protect, their families. 31 states have passed laws that could prevent all convicted abusers from purchasing or possessing guns. Michigan does not, yet, but we could. Senator Stephanie Chang and Representative Amos O'Neill have introduced bills to protect survivors and make sure that abusers are prevented from possessing guns for 8 years. It's not enough to just remember, to memorialize, or to honor. We have to act. And the time for action is now. So now I would like to introduce an incredible leader of our state that you all know. She's always standing shoulder to shoulder with us. It's our own Attorney General, Dana Nessel.
So thank you all for inviting me here to be here today to speak to you about this incredibly important topic and these important bills that are pending that I intend to speak on behalf of for the state Senate today. As the top law enforcement officer in Michigan, I have long supported enacting reasonable gun legislation into state law and to do everything that we can to protect survivors of domestic violence. And as a very long time prosecutor and also a defense attorney, I have handled countless cases involving domestic violence and other crimes against intimate partners or family members. There is a clear, undeniable connection between domestic violence and firearms and then assaultive conduct that follows.
Once enacted, common sense measures like these will remove deadly weapons from the hands of people who have been convicted of violence against the people that they are supposed to love the most, and from those who are at risk of perpetrating great harm. Now, in my experience, and I will tell you, having handled hundreds and hundreds of these cases, the vast majority of domestic homicides are perpetrated by an intimate partner or family member who legally possessed that weapon. And that's something very important to note. Now, I am confident that these bills will receive widespread support from the residents of this great state. In fact, they already do. The Department of Attorney General is committed to protecting and supporting survivors, and when someone bravely steps forward and reports their experience to us, we believe them, and we do what we can to support them. But we have to do even more. Now, to bring up another subject that is pending right now, and I think is inextricably related to what we're talking about, is that my department helped draft the Starkeisha Thompson Victim and Witness Privacy Protection legislation, which will shield victim and witness personal information and public police reports from being provided to defendants and defense counsel without a court order. And without such measures, law enforcement agencies I visited all around the state have had victims and witnesses who have refused to come forward and refused to participate in the process due to fear of retaliation by the defendant. We also have to be encouraging our state legislators to pass those as well. We have to be doing everything we can to support crime victims as they go through and navigate this difficult process, because at the end of the day, the justice system is there to serve them. Now, this year alone, I've already met with dozens and dozens of victim advocacy groups and child advocacy centers and law enforcement agencies to talk to them about this proposed legislation and about the implementation of the new extreme risk protection order, which is going to be going into effect next year. And of course, about the Department of Attorney General's new address confidentiality program, a tool to protect the privacy of crime victims by providing an alternative address for them to use on public records, that just went into effect yesterday. And I encourage survivors who are interested in participating to visit michigan.gov/AGACP for help finding an application assistant in their area. In each of the communities I've visited, and I've gone to the UP, I've been to the Northeast, the Northwest. I just came back from a trip from the west side of the state, and of course I've been in the metropolitan Detroit and Lansing areas. In all of these areas, I'm reminded of the importance of addressing the gaps in Michigan law that allow domestic abusers to have access to firearms, and the importance of protecting victim and witness privacy, and the importance of providing resources so that each member of our community can feel safe and secure in their own home. This critical legislation is long overdue, and it would continue the great work that the legislature has already done this term. And let me say this, I know that it's a popular narrative to talk about this being controversial in nature. Well, I have been around the state, as I've indicated, and I have talked to sheriffs of both parties, I've talked to prosecutors of both parties, I've talked to domestic violence, sexual assault, human trafficking, survivor advocates of all parties all around the state of Michigan. And let me tell you this, it is not controversial to protect crime victims. It is not. It is popular, it is important, it is essential, and we have to keep moving forward on these pieces of legislation. And through these important measures, the state of Michigan not might, but will save countless lives of residents who are all around this state and who are deserving of no less. They need our protection, and we expect the state legislature and the governor to deliver on that. So, thank you so much for allowing me to come here and talk to you all today. These are essential, life-saving measures for countless people, and it is time to make them part of Michigan law. Let's get it done.
Who has turned her story
of surviving domestic violence into helping others, and she does incredible work. She founded an organization called Voices of Color, and her name is Tanisha Ash Shakur. Please welcome her.
Good morning. First, I wanted to thank Attorney General Nessel. It means so much to us as leaders that you are elevating this cause and that you were here today to speak on that. So thank you again, Attorney General Nessel. In 2007, an undergrad friend and I decided to become exclusive in a relationship 3 months after he moved in with me. The official title is What Started the Abuse. Verbal, mental, emotional, physical abuse kept me on my toes. How I love to vacuum to keep the carpet sharp, and everyone can remember just how when you vacuum the floor there are those dark lines in the carpet. But that soon changed when my abuser used those lines to accuse me of cheating if the lines were light, despite that they were merely my footprints. The accusations enhanced the abuse, and now I was being raped to be taught lessons and to admire him romantically. 9 months in, he didn't want to chance me escaping, so he didn't go retrieve his gun from his SUV. Instead, he put a knife to my stomach and stated to me he was going to call his parents to tell them he was going to murder me that night. I was held in a bedroom for over 3 hours with no one to save me. I silently cried and prepared for my life to be over. Finally, someone in his family answered the phone and talked him into putting the knife down, and we went to bed as if nothing ever happened. So I stand here today because I survived. But now I suffer from pseudo-seizures and vaginismus because of the ongoing trauma that my body has experienced. As Celeste said, it is important that we come together to mourn, to grieve, and to remember. But I say to you that that is just not enough. To truly honor the 50 Michigan women and 20 children killed by their abusers each year, we have to make sure that there are fewer shoes on these steps every year. And that's why we need to pass Senate Bill 471 and 472. I will say that again. And that's why we need to pass Senate Bill 471 and 472. We need to turn our power, our pain into power. We need to turn our grief into laws and our mourning into more organizing. We must transform our personal healing journeys into the healing of this entire society. We can start by passing these laws, protecting women and children, and ensuring that no one convicted of domestic violence can get their hands on a gun. Thank you.
Samantha Martin, and she is going to talk about the work that she does as it relates to protecting children. She's with the Children's Defense Fund.
Hi, everyone. I want to start off by thanking you, Tanisha, for your bravery and your courage and sharing your story with us today. It's really inspirational. My name is Samantha Martin. I'm a policy associate with the Children's Defense Fund, and I'm here today to remind you that one of the groups that is most devastatingly impacted by the effects of domestic violence are children. Innocent children who rely on us, the adults in their communities, to protect them and keep them safe. We know that just being in a home and witnessing violence causes toxic trauma that realigns DNA and prematurely ages children by 7 to 10 years. And that's the outcome for the children that survive. We mentioned earlier that 50 women are killed by their intimate partners each year in Michigan. Well, 20 children are also killed alongside them. We know that Domestic violence is 5 times more likely to result in death when an abuser has access to a firearm. It feels like each week we turn on the news and we're hearing about a new mass shooting in our schools, in our grocery stores, at parades and concerts. But it's important to note that the most common location for mass shootings in our country is in the family home. 68% of mass shootings are the result of domestic violence, and more often than not are men who use a firearm to kill their entire family. Just earlier this year, in Fruitport, a man killed his mother-in-law, all of his children, and then himself. Again, this was an abusive relationship, and his wife was in the process of divorcing him. We don't need to stand by while one more family perishes because an abuser has access to a firearm. All children deserve the opportunity to thrive and grow and experience joy. We can start by taking action today and by passing Senate Bill 471 and 472. I thank you all for being here today, for standing for children and their families. And I'd like to invite you to march with us over to the hearing for these bills at noon after this press conference. Thank you. Gun owner with Giffords, who is going to speak about the incredible work that they do as an organization. I'm gonna stand so everybody can see me. No, it's okay. This is good. Yeah, we're good. So, like Celeste said, I am Kristen Perry with Giffords Gun Owners for Safety. As a therapist, gun owner, advocate, and mom, safety is at the forefront of my world. I've been a therapist for almost 20 years. In those nearly 2 decades, I have worked in community mental health, foster care, and private practice, and I have seen domestic violence impact families in all of these communities. I have also seen the devastating impact of gun violence in families across the board. Mass shootings grab the headlines, but far more often it's guns at home that pose the greatest threat. We don't see the headlines of the catastrophic combination of guns and homes with abuse. As a therapist, I assess for client safety, including asking about the use of drugs and alcohol, if there's any violence in the home, and I ask about the presence of guns in the home. I know when a gun is present in a home with domestic violence, there is a 5 times greater chance of death. Not only is a person tragically and needlessly killed, but children are forced to face a world without their parents. Families go through life events with an empty seat at the table, and communities lose the individuals that help them thrive. One human casualty leaves a ripple effect of trauma. I met with a child whose father had experienced his own traumas. He had not yet begun to heal those wounds, and they festered into violence towards this child's mother. This mother came to me describing an escalating pattern of violence. We created a safety plan for her and her children, including removing a firearm from the home. This mother and her children reached safely, luckily. Not all families do. Today we remember those taken by domestic violence because we have seen too many casualties. In addition to being a mother, I'm also a gun owner. I have weighed the balance of safety of having a gun in my home versus not, and I chose to own a gun to protect my family. I store that gun in a safe at all times, but I know I have the responsibility to remove that gun from my home if other factors make that firearm a tool of danger instead of a tool of protection. If I was a threat to someone, or if someone in my home was a threat to me, access to that firearm would have to be removed. I know other responsible gun owners want a safe world as well, and a safe world starts with a safe home. This means preventing access to firearms to those abusers that pose a danger to themselves and loved ones. Losing sleep and crying over too many kids and parents taken by guns propelled me to become an advocate for gun safety laws. Too many of those were taken by the hands of someone they loved with a gun. But love should not kill. We must have laws in place to prevent deadly firearm violence within families and keep our loved ones at the dinner table, parent-teacher conferences, and bedtime tuck-ins. Join me in honoring those already taken by creating change through laws that keep us safe. Thank you.
As an organization within Moms Demand Action for many years, and the students have really taken the work that has been done into their own hands and done incredible things to protect their fellow students from harm. And so I'd like to introduce Addie.
Hello, my name is Addison Collitz, and I'm a student at Michigan State University and a leader at Students Demand Action. I began my involvement as a student activist around 4 years ago, and I am here in support of Senate Bill 471 and 472 to prohibit convicted domestic abusers from owning or possessing a gun. Today, we have heard a vast number of profound stories of how domestic violence has shaped many of our lives and our loved ones. There are countless stories of domestic abuse that go unheard of because lives are taken. But that doesn't mean their story should go untold. I am here to tell you about Laura Wallen. Sorry.
You got it.
Laura Wallen was a 31-year-old teacher at Wild Lake High School. She was a daughter, a sister, a friend, and a soon-to-be mother before her and her unborn child's life was tragically ended by her boyfriend. To me, Laura Wallen was one of my greatest mentors. She effortlessly taught me and others to create positivity wherever I go, and never forget that even the farthest of goals can be reached through strength and dedication. Her love and leadership helped me reach unimaginable points in my life that I never thought I could do. I am here today telling her story because her life was taken. But Laura Wallen's legacy will forever be remembered by myself and others. Every month, an average of 70 women are shot and killed by an intimate partner. Those women, like Laura, deserve a chance to tell their story. Disarming domestic abusers statewide can prevent this from happening to any woman or their loved ones. I know if this bill is passed, we can continue to give them the voice they deserve. Thank you.
Thank you, Addie, for your bravery. And I know I was stumbling with my words in introducing Addie because I didn't prepare the introduction super well today, but I want to really stress that Students Demand Action, as well as March for Our Lives, and all of the student-led organizations that are fighting to end gun violence, they shouldn't be put in this position. They should not. And I applaud the work that they do, and I support them, and I honor them by my actions as well. And so we just ask that all of you do that. Take your takeaway for today should be to continue acting, continue asking for gun safety measures. As we talked about, we are going to be listening to the Senate bill hearing 471, 472 at 12 p.m. so we can march right over there to the Binsfield building. And that is our call to action for today, and we just thank all of you for being here.
Thank you. I'll entertain a motion to adopt the committee minutes from the September 12th, 2023 meeting. Motion made by Senator Irwin. Without objection, the minutes are adopted. Today, we are taking up Senate Bill 471 and 472. And I'm very excited to see all of you here and looking forward to hopefully a very informative hearing. So, Senate Bill 471 and 472 are a couple of bills that I've worked for quite some time on. I'm very excited to speak today about legislation that I believe is a critical issue in Michigan, one that I've worked on for 4 terms in a row. And I want to start by expressing appreciation to Wayne County Prosecutor Kim Worthy's office for coming to me more than 5 years ago with this idea and working with me alongside so many domestic violence experts, gun violence prevention groups, and law enforcement stakeholders to develop and refine this legislation over the past many years. These bills have had strong bipartisan sponsorship, and I have been very thankful to partner with Republican colleagues over the years, including former Senator Wayne Schmidt, former Representatives Mary Whiteford and Dear Rendon in this effort. Nearly half of all women murdered in the United States are killed by a current or former intimate partner, and more than half of these intimate partner homicides are by firearm. Domestic violence is a serious, prevalent issue and one that we can continue to take important steps to address. Senate Bills 471 and 472 would help keep firearms out of the hands of people very likely to be a danger to others, individuals convicted of misdemeanor domestic violence. They would be prohibited from carrying, using, possessing, purchasing, selling, or transporting a firearm for 8 years after the completion of their sentence. We know that domestic violence is something that can escalate. What might be a more minor incident the first time or the second time might become a more violent or dangerous offense later on. And that is exactly why we need to pass this law to help prevent future violence and abuse in the home involving a firearm. The bills would bring Michigan law into partial alignment with current federal protections, allowing state and local prosecutors to enforce misdemeanor domestic crime prohibitions. 31 other states and Washington, D.C. already have a similar law in place, including red states like Kansas, Alabama, Tennessee, South Dakota, Louisiana, West Virginia, and Indiana. I want to be clear that after the 8-year period expires, the person does regain the opportunity to possess a firearm. You will hear more about statistics later from Dr. April Zioli and many stories and statistics from other survivors who are here, stakeholder groups and justice system officials who will testify, so I won't go into other statistics except to note one more thing. According to the American Journal of Public Health, women are 5 times more likely to be murdered by an abusive partner when the abuser has access to a firearm. During this hearing, you will hear very clearly that the presence of a gun in domestic violence situations increases the risk of homicide. When restrictions are put in place to limit or prevent convicted abusers from accessing firearms, the number of intimate partner murders drops. The argument here is simple. When you have a gun in a situation where there's an individual with a record of domestic violence, there is a much greater likelihood that the victim might die. When there isn't a gun in that situation, lives can be saved and serious injury can be prevented. Survivors of domestic violence endure unimaginable pain and betrayal, and it is our responsibility to ensure that they have the peace of mind knowing that they will be protected from threats of gun violence at the hands of their abusers. This legislation is a common sense solution, a bipartisan solution to protecting domestic violence survivors in our state. Thank you, and I'll take some questions from committee members, starting with Senator Winstead.
Mine is more of a comment that the Second Amendment rights are in the Bill of Rights, the second of the Bill of Rights, and thus are extremely important that when we're dealing with the constitutional right, we get it correct. My staff said they were notified about 18 hours ago about this hearing. We have a complete, the audience can't see, jam-packed committee room here. I have, I think, one person out of this jam-packed committee hearing because the notification was so late I couldn't get anybody else here. But obviously, a lot of people were given advance notice to fill an entire committee room of people and expert witnesses to come in and testify. Very similar to what we had in the first gun hearing, 6 hours of testimony. I had one person that was allowed to speak even though I had a ton of people there. I'm very, very discouraged about the direction of this committee in terms of packing in supporters, expert witnesses, and for the other side, not even giving them notification to be able to get somebody here to be able to testify. This seems to be an ongoing situation. I would never have tolerated when I chaired Judiciary Committee. Thank you.
Well, thank you, Senator, for your comments. I will remind everyone of during the many hours of hearings earlier this spring, there were lengthy comments from folks on both sides of the issue, and we provided very I would say, very generous opportunities for folks to weigh in. And of course, we will continue to do that, as I am the chair who is very committed to ensuring that we hear from all sides. I think what you're seeing today is that there are a lot of folks across the state who care very deeply about this issue. There has been many years of folks who have supported this issue, and that is why there are so many people in this room today. Senator Johnson?
Thank you, Madam Chair. I was wondering, because there's already a federal law for this, why do we need a state law? Because we do have a federal law as I read it.
Yeah, no, thank you for the question. It's one that I get a lot actually out in the community as I talk about this issue. And actually the answer is pretty simple, but it's a great question. Although we do have a federal law in place, we need to give our state level prosecutors and law enforcement the tools to be able to enforce this kind of prohibition. Right now we have nothing on the books here in Michigan state law to help ensure that we are protecting domestic violence survivors from those who are convicted of misdemeanor domestic violence. So that's why, in conversations with Kim Worthy, my prosecutor, other prosecutors, and law enforcement officials, this is something that they want. This is something that they want to be able to have as a tool to be able to help protect survivors at the state level.
Thank you.
Thank you. All right, so we will next hear from Rick and Martha O'Million from Plainwell, Michigan.
Thank you for inviting us. We did bring our daughter with us. Is it okay if we put her up? Maggie. We're going to talk about her. As you said, we are Rick and Martha O'Million. We're from Kalamazoo County, and we live near Plainwell, Michigan. It's between Kalamazoo and Grand Rapids. We want to thank you for the invitation to come and speak in support of the Domestic Violence Offenders Restriction Bill, Senate Bill 471 and 472, currently being considered by this committee. We are survivors of domestic violence and gun violence. We speak today as grieving parents, and these are our own words that Martha and I have composed, and I'm delivering them. We'll talk about how we want to do this. Our daughter, Maggie Wardle, was murdered by an ex-boyfriend on October 18th, 1999, 24 years ago, in a dormitory room at Kalamazoo College. Her attacker bought the shotgun using a driver's license with his college address on it from a local firearms dealer in Kalamazoo. He bought it a week earlier, and he hid it in his room before he lured her to his room and killed himself after stealing Maggie's life. For the last 25 years, we have advocated in Maggie's memory, testifying to a 2001 bipartisan Michigan Domestic Violence Task Force about the need to designate dating violence as domestic violence, which was not happening at that time. We had no idea when Maggie died that she didn't have protections. But when that committee, that task force made the recommendations, they guaranteed protections to victims of intimate partner violence. A significant change in the law, kind of like you're considering today, to make a difference. We've spoken in local classrooms to young people about healthy relationships and the warning signs of dating violence. We've advocated through groups like Million Moms March, the Brady Campaign, and now Moms Demand Action for the changes in gun laws we support to protect women, children, and families. We were here earlier this year, outside in the lobby, in support of the secure firearms storage, universal background checks, and extreme risk protection orders legislation that recently passed in the Michigan legislature and were signed by Governor Whitmer. Today, we speak in support of these bills that would impose firearm ownership restrictions on those with domestic violence convictions to protect women and men, children, and families. These bills, when passed and enforced here in Michigan, can support current laws and protective order procedures, and as you heard, federal laws, which could save the life of someone like Maggie in the future. Over 4.5 million women have been reported being threatened with a gun in the U.S. by an intimate partner. Nearly 1 million women alive today have reported being shot or shot at by intimate partners. In some instances, with these bills today, we can stop these potentially dangerous situations before a firearm is used. A convicted domestic violence offender, male or female, has shown by their past behavior that access to a firearm is not appropriate at that point in their life. This is not a violation of their rights. or a threat to those who are responsible gun owners. But it is a reasonable reaction to past behavior and the history of the abuser. That's what's at stake here. We can't look back 24 years and say that this type of law would have specifically saved Maggie's life in the situation she found herself. At the time, we did not understand as her parents the extent of his abusive need for power and control over her. She was emotionally abused by him in their interactions and made to feel that she owed him her understanding. He was not physically abusive. He was not charged with domestic violence in his past, as this law would specify, but he did show red flags that he could hurt himself. And he was angry with her that year, and he bought a gun. Purchasing that shotgun and hiding it in his dorm room for a week was his final threat of power and control to our beautiful, strong, assertive daughter. He believed that accessible firearm was his power, his last chance to stop her bright future, the one without him in it. The moment that he pulled out that shotgun for Maggie to see is forever etched in our minds. If laws existed like the bills you're considering today and were in place, we would have helped Maggie in any way possible to protect her, as we always did in her short life. She's not defined by his violence, but rather by her character and her family's love for her. That is why these bills you consider today and others you passed this year are so important to us. They will save someone's life and give them the chance to live a full, meaningful life, the chance Maggie did not get. Many instances of gun violence, like the violence that took Maggie, are fueled by domestic violence and misogyny. These bills you vote on won't end all gun violence or stop all other means of gun violence that you might want to, of any violence that you might want to consider. It won't address mental health issues of those who are at risk of hurting themselves or others. It won't solve all the problems of guns in the hands of criminals. You will have to pass other laws to do that, and you should. Today we ask that you vote on and pass these bills and save lives one at a time. We want to thank all of our family, friends, and Maggie's classmates and friends for supporting us and standing with us always, remembering Maggie.
Thank you very much for sharing her story and for your courage for being here today. Do we have any questions from committee members? Senator Shink?
Thank you for being so strong to come and talk to us about this. I mean, as I'm sitting here thinking about being on the edges of domestic violence in my life, not ever having actually experienced it, and things that I had pushed back in my memory that were scary and dangerous. And then thinking about how hard it must be for you to talk about this here, and maybe, you're well practiced in speaking, but I'm sure you'll never be well practiced in missing your daughter. So I just want to.
Thank you.
Thank you so much. Thank you so much for saying that. Yes, it is very difficult, but I will do this to my last breath because Maggie should still be able to be here. Thank you.
Thank you both so much.
Why is it red then? I think we're turning red.
Well, nonetheless, great to be here this afternoon. Good afternoon, Chair Chang, Vice Chairs Shink and Runstead, and members of the Senate Judiciary Committee, and thank you for having me and for giving me the opportunity to support this incredibly important legislation. Now, I'm here today to voice my strong support of Senate Bills 471 and 472, which would, as you know, prevent people convicted of domestic violence misdemeanors from possessing or owning a firearm for 8 years following their conviction. Now, specifically, this legislation would prohibit a person convicted of a misdemeanor involving domestic violence from possessing, using, transporting, selling, purchasing, carrying, shipping, receiving, or distributing a firearm or ammunition in this state until the expiration of 8 years after all of the following conditions. The person has paid all fines imposed for the violation,
The person has served all terms of imprisonment imposed for the violation. The person has successfully completed all conditions of probation or parole imposed by the violation. I applaud you, Senator Shang, for introducing the significant legislation. I'm very proud to be here today. These important bills will help protect victims of domestic abuse from gun violence, full stop. This common sense measure is long overdue and will help make safer communities, and it will save lives. Now, as the top law enforcement officer in the state of Michigan, I have long supported enacting reasonable gun legislation into state law, and as a very long time prosecutor, also a defense attorney, I have handled countless cases involving domestic violence and other crimes against intimate partners and family members. And let me say this, there is a clear and undeniable connection between domestic violence and firearms. Domestic violence and firearms are a deadly combination, and survivors are at the greatest risk of harm and potential homicide after leaving an abusive relationship. Now, recent statistics and studies only highlight the deadly intersection of domestic violence and firearms. Abusers with firearms are 5 times more likely to kill their female victims than abusers without firearms. And every month, an average of 70 people are shot and killed by an intimate partner. Nearly 1 million women alive today have reported being shot or shot at by intimate partners, and over 4.5 million women have reported being threatened with a gun by an intimate partner. Now, that study also found that while the deadly intersection of guns and intimate partner violence affects all women, it has a disproportionate impact on women of color, as well as pregnant and postpartum women. And in addition, segments of the LGBTQ+ community and people with disabilities are highly vulnerable to severe forms of relationship abuse. Now, these statistics are shocking, and I am personally infuriated that thousands of Michigan residents are targeted each year by the scourge of senseless, preventable gun violence in our state. And we've seen just recent data that indicates that every year an average of 466 people in Michigan die by gun homicides. 1,798 are wounded by gun assaults at a rate of 5 homicides and 18 assaults for every 100,000 people. And the vast majority of domestic violence related firearm crimes are committed by people who are using a legally obtained firearm. These are not illegal weapons, they are weapons that were legally purchased. Legislation like this and Michigan's newly passed extreme risk protection orders are practical and effective tools to combat gun violence. Once enacted, common sense measures like this will remove deadly weapons from the hands of people who have been convicted of violence against the people that they purport to love the most. And I am confident they will receive widespread support from the residents of this great state. And I will say anecdotally, I have spent the summer traveling all around the state of Michigan, just got back from a trip on the west side of the state. Before that, I was in the Upper Peninsula. I've been in the Northeast, I've been in the Northwest. I'm routinely in the Lansing and metropolitan Detroit areas. And I will say this, sheriffs, prosecutors, domestic violence, survivor advocates, CSC survivor advocates, nearly uniformly support these laws. Not just Democrats, Republican sheriffs, Republican prosecutors support these as well. This is a bipartisan issue. The Department of Attorney General is committed to protecting and supporting survivors, and that includes promoting legislation like this, which will help reduce the number of gun-related deaths caused by intimate partners and family members. And at the Department of Attorney General, we have a grant-funded unit dedicated to the investigation and prosecution of domestic violence, sexual assault, and stalking cases, as well as homicide cases. I'm thrilled to have the heads of our sexual assault and domestic violence unit, Danielle Bennis, is here today with me, as well as the chief of our criminal trials and appellate division, Danielle Heckman-Clark, who has made her career out of prosecuting these kinds of cases, both highly trained and experienced in conducting offender-focused, victim-centered, and trauma-informed investigations. They're here if you have any questions and want to talk about the specifics as to how this would apply, or many, many, many cases. I would say hundreds, but I think it's thousands of cases that you guys have handled in this realm. I also brought with me my acting chief legal counsel, Linus Bankard-Lynn, who came from our Solicitor General Division, in case you have any questions legally as to how these cases might fare in the event that they are challenged and there's judicial scrutiny on these. We feel very, very strongly that these bills will be upheld in the courts, and we've analyzed a lot of cases throughout the country, and we feel very confident in saying that. And of course, Aaron McGowan is here with us as well, who has helped us in terms of scrutinizing these bills on behalf of our legislative division. But I will say, I've met with so many victim advocacy groups, child advocacy centers, law enforcement agencies, and we are always reminded of the importance of addressing the gaps that exist in Michigan law that allow domestic abusers to have access to firearms. Federal law currently prohibits, as you noted before, purchase and possession of firearms and ammunition by people who have been convicted in any court of a misdemeanor crime of domestic violence. But we still need these laws. There are many people who still come into possession of weapons illegally despite those federal laws. I almost never see them prosecuted federally, I should tell you. And this legislation will be a tool to further protect victims, survivors at the state and at the local level. We ought to join the overwhelming number of other states that already have closed the gaps in federal law pertaining to people who commit crimes of domestic violence. And as you know, and I think you've noted, already 33 states in Washington, D.C. already have domestic violence misdemeanor gun prohibitions. And these states range in both geographical position, political beliefs, demonstrating that this measure has widespread bipartisan support. But what we see from these 33 other states is that this legislation in place in those states works. It works. And we see recent studies of that in association with firearm laws, with IPH, where domestic violence restraining orders and firearm restrictions are in place. At least minimally an 8% reduction in these types of cases, and that is certainly not nothing. Researchers report that the only states that specify the relinquishment of firearms already possessed of the EPRO law experience typically associated reductions of approximately 10%. That's a lot. That's a lot of people not getting killed, a lot of people not getting shot. This critical legislation is long overdue, and it would continue the great work that this legislature has already done this term to help stem gun violence and prevent unnecessary firearm-related injuries and deaths. It's a common law, a common sense law. It'll make our community safer from gun violence. It'll protect victim survivors from further and perhaps deadly abuse. And I very much appreciate the time that this committee has taken to allow me to make my remarks. I have the experts of all experts sitting next to me today, so if you do have specific questions, I would welcome you to ask those questions at this time.
Thank you very much, and thank you to your whole team for all of the years of work you've been doing on this issue. Senator Winston.
Thank you, Madam Chair. With these bills, like I spelled out earlier, it's extraordinarily important to get them right. And the fact that we have all these people from all over the state, all pre-notified, and then we get a last second to make sure we don't get people that can come in is very discouraging. The testimony that we've had so far, the horrible case of this shooting, the testimony is this bill wouldn't have prevented that one. The Emmett shoot that was right after that, that was an individual who had a felony, firearm felony that should have been prosecuted. It was pled down, a terrible case by the prosecutor who dropped the ball. So what I'm trying to do here today is get to the specifics of this bill and not ancillary bills of everything under the sun, but the specifics of this bill. And you mentioned the number of women that were shot at or were threatened. Everyone on this committee would be 100% supporting going after every one of those perpetrators with everything we've got. There is no question about that. Again, it's throwing in something that is much broader here that we'll get into if my one person that is here is allowed to testify about the specific issues that really need to be addressed. I think we might be able to get everybody on this committee if these specific issues are addressed. You keep referencing that this bill has law enforcement. I understand this bill was introduced about 2 days ago. So all these law enforcement are familiar with the specifics of the bill. I couldn't reach anybody to get here, but you say all these people are supporting this bill. I don't know how that happened. I understand 33 other states have something similar, and then reference to the success of those. The same thing happened when we did the red flag bill. In Florida, they're saying a Republican red flag state has red flag bill. The reality is there, the police department makes the complaint and does the presentation in front of the judge. Here, it could be a next door neighbor, a friend. So there's a lot of specific differences within state laws that are references. They all have this. All the law enforcement here has been apprised of this bill. When I doubt, since I just got notification, one out of a committee full of people that were pre-notified of this bill, I think a lot of your testimony is called into conflict with what I just addressed here.
So before, I just want to clarify a few things about the committee process and the work that we did on this set of bills. Just a quick thing on the committee notice. The committee notice was 2 days ago at 2:50, which was well ahead of the required 18 hours. And I believe my staff had a communication with your staff earlier than that. So, and then in terms of the work that we've been doing on these bills, first of all, these bills have been, as I mentioned earlier, introduced 3 terms before, had a lot of work done on these pieces of bills. And part of the reason why we just introduced these bills is because we had many months of work with your office, with various law enforcement groups representing law enforcement across the state to give us their feedback, as well as, of course, our domestic violence groups who gave us also very critical feedback, as well as my own county prosecutor. So just as with every other piece of legislation, there's been a lot of work on these bills, and they're also not new. They're bills that have been around for several terms in a row, which I'm sure you're very familiar with.
Well, and my response to that would be, when I'm talking to these sheriffs, and when I'm talking to these prosecutors, no, I don't say, what do you think about Senate Bills 471 and 472? What I do say is, what do you think about bills that would outlaw the possession of a firearm by a person who has been convicted of domestic violence for 8 years until unless they have completed all the terms of their probation in the 8 years following that? And what I get routinely, time and time again, is incredibly strong support. Now, I will say they would not have been able to use that weapon in order to murder or to attempt to murder an intimate partner. And of course, many of those cases, they were successful. They ultimately were homicides that were prosecuted. And obviously, I welcome you to question them as to any of the cases that they've had. But, you know, this is an issue that's been around for a long time. It's been an issue that in the prosecutorial community, we have discussed for a long time. And it's an issue that we have analyzed state by state by state. And I don't believe that the laws that are in place in these many, several dozen other states are significantly different from the laws that are being proposed here today that we know for a fact have saved lives.
Have you researched all those states? You had to make this assertion because the devil is obviously in the details. But you're all pretty standardized bills within every one of the states. Is that your assertion?
Yeah, they're pretty basic, which is that
you've reviewed them all.
event.
It's a question.
Linus, would you like to speak to this? He is my chief legal counsel, and I know that he's done an exhaustive review. And part of the reason for that is because, again, it is our great interest. It's not just we're not here to support bills that are going to get overturned in the courts. We're here to support bills that will withstand judicial scrutiny, and that is why, as my chief legal counsel, I've asked Linus to do an exhaustive review of this. If he may he respond to that?
Absolutely, thank you.
Thank you. As the Attorney General mentioned, I looked at this with an eye to constitutionality, with an eye to whether it will withstand challenges. So in that regard, I've mainly looked at the federal law that is very, very similar to this one. There are differences. There are not differences that are really relevant to the Second Amendment or a constitutional challenge. And it's the same with the other states. I think the devil can hide in the details, but I don't think that that's the case here. I think that Michigan can plot its own course in terms of the policy. When it comes to the constitutionality of it, these laws are upheld because it is constitutional to tell someone who's convicted of a violent crime that they're no longer allowed to own a firearm anymore, especially if it's limited to 8 years as we have here. I don't think it has to be limited to 8 years under the Second Amendment. That's the language in the bill.
But my exchange with the AG was not specific to the constitutionality.
Sure.
She was going on about how these 33 other states have passed very similar bills. But as we just talked about, and as I just talked about, from one state to another on the red flag, very critical information left out by the media, left out by the sponsors, left out by everybody, and presented as though basically these states are all passing the same kind of red flag law when there was huge disparities.
Okay,
I believe there's 33,
sorry, we are
I'm gonna
talking
finish,
about
33 states could be completely
471.
different.
And 472, I think we've been thank you very much for your testimony. I think we've all been very clear about what we're talking about today. Senator Shink.
Thank you. I think given the turn of the conversation, I'll just keep my comments to myself.
Thank you for your testimony, and thank you again for all the great work that you, Senator Santana.
Thank you. I'm just a little confused. Can you clarify the opinion from the People versus Lockridge, why that's important to Senate Bill 471?
Lockridge is in regard to the sentencing guidelines?
Yes.
I don't know that there is any nexus or correlation necessarily, unless you're talking about people who are convicted of having illegally possessed firearms because they were ineligible due to a domestic violence conviction. So is that what you're referring to?
No, I'll follow up with the bill sponsor. Thank you.
Okay.
Thanks very much.
Thanks for having us.
My name is Tom Lambert. I am the Legislative Director for Michigan Open Carry. Thank you all for your time today and for the opportunity to testify. What we have here is a typical bait and switch. You've heard lots of testimony, lots of comments on domestic violence. What you have in front of you is a lot of language not about domestic violence. You've heard the stories, you've heard comments that when it comes to domestic violence, there's definitely concern. You've also heard comments that this legislation has been put forward multiple terms in the past, and there's been a lot of work on this. And we really know what we're doing here because we're working really hard on this. And yet, it doesn't apply to domestic violence. So what's actually going on here? Why the lack of effort? Why laziness, the lack of focus here? That's where we get into, again, bait and switch. The bill primarily focuses on a number of different sections in the penal code. And it says, if you are convicted of one of the misdemeanors in those sections, then you are considered prohibited due to acts of domestic violence. However, there are many, many misdemeanors in those sections that have absolutely nothing to do with domestic violence or even violence of any sort whatsoever. For example, calling a commercial solicitation via communications device after 9 p.m. That could prohibit you from possessing firearms or ammunition for, let's say, 8 to 15 years, depending on all the stuff involved. Now, certainly not supportive of such a thing. Should it result in this prohibition? I think absolutely not. You heard a comment that, well, there was an exhaustive review of this legislation and it will absolutely stand up to constitutional scrutiny in court. Will it? Ask yourself. Prohibiting somebody because they made a commercial call after 9 p.m. Do you think that's going to stand up in court? Honestly, anyone here, does anybody think that's going to stand up in court? Federal courts are already striking down prohibitions based on non-violent felonies. How are courts going to view non-violent misdemeanors? This is an immense issue, an immense oversight, and one that doesn't happen with a significant amount of work. We've also heard no example so far of where state law was inadequate. Now, if it's truly federal law that we want to mimic, which is another thing we heard. We heard, what was it? We're focused on domestic violence and we're mimicking federal law. No, this is absolutely not mimicking federal law. This goes well beyond federal law. That's already coming into question a little bit in and of itself in matters that are unquestionably unconstitutional and unquestionably have nothing to do with preventing violence. I'll end my testimony with suggesting, as this continues to get worked out, a focus on restoration of rights. There's some clarity that could happen there. And I'm going to guess, without speaking for anybody, that perhaps some extra support could be obtained through such focus. One last thing. The bill does prohibit people convicted from selling their firearms. United States Supreme Court decision, unanimous decision in 2015. Henderson v. United States. The Supreme Court unanimously held that people who are convicted of a crime where they become federally prohibited from possessing firearms still have the right to alienate all their property. They can't necessarily have the guns, but they are entitled to the right to the value of those firearms. So you may consider allowing people who do become prohibited to still get rid of their firearms in a manner where they can get their value back. Otherwise, you have yet another way this bill is unconstitutional. That I'm happy to answer any questions.
Thanks very much for your testimony. I look forward to, I just want to point out we do have a number of domestic violence experts who will very clearly, again, reiterate the link between these bills and domestic violence and that link between firearms and domestic violence. Also, thank you for the new experience of having our committee being called lazy. That was definitely interesting and new. Senator Runstead.
Thank you. It sounds like everyone is in agreement in terms of trying to prevent domestic violence, trying to prevent gun violence. That it was referencing what I went to earlier, and that is the devil's in the details, making sure that we get things right, that we're not violating constitutional rights, but we're also not writing something that really is going to do a lot of harm, along with potentially some good, and that with some modifications, maybe this bill could be made to be a good bill. Would you agree with that?
It is possible.
Then I don't know if the sponsors are willing to work with that, but I think we all agree it should be the best bill possible, and I don't believe that we've had enough time to vet through this in order to make that possible. So hopefully the sponsors will be willing to work with you and me and others to make it a better bill.
If it's truly public policy that we're interested in, and truly stopping harm that people are interested in, and truly creating legislation or law that will stand the test of time, I would hope such concerns are taken into account.
Thank you.
And I think everyone in this room knows that I'm always open to suggestions, always open to feedback. So looking forward to seeing something in writing. Senator Irvin.
Thank you, Madam Chair. I don't have a question for you, Mr. Lambert, but I did want to direct you to page 4, starting with line 18. It starts with, quote, misdemeanor involving domestic violence means, and that goes on to explain the definition of that in this proposal. And I think that is maybe the section of the proposal that you missed before coming to offer your testimony today. Thank you.
Thanks very much. Up next, we have Christina Josephy from Michigan State Police.
Madam Chair, Vice Chair Shank, Vice Chair Runstead, for the opportunity to testify in support today of Senate Bills 471 and 472. I think most of you know me as your liaison to the Department of State Police, but today I testify in a larger capacity. Laws on domestic violence are my area of expertise and responsibility. I started studying intimate partner violence more than 15 years ago. I worked as an assistant prosecutor handling the majority of our domestic violence cases, overseeing crime victims' rights. I'm responsible for legal instruction to future law enforcement officers at our training academy in domestic violence and crime victims' rights. I'm responsible for editing the criminal law and procedure manual for police officers in Michigan with regard to those topics. And it's why I'm a trooper. Cases, victims, and offenders of domestic violence are the reason that I became a trooper and left my job as an assistant prosecutor. I wanted to be the person responding to those 911 calls, the person interviewing victims, witnesses who are so often children, and suspects, and ensuring from the earliest stage possible that we obtain justice in these cases. I know this law, I know this practice, and I know the practical implications of the law and these bills. I've prosecuted them, I've investigated them, and I've sought justice in these cases in I think all the ways you can imagine. I'm intimately familiar with the barriers that exist for conviction in cases involving domestic violence. I understand these things on a practical level, not just in theory. I know how a law enforcement officer is going to realize that someone is a prohibited person, a convicted person under this statute or this bill. I understand how a prosecutor is going to review a police report, make a charging decision, engage in plea negotiations, and seek a conviction. And I understand how Senate Bill 471 helps them do that. I understand what it takes for someone to be convicted. And I understand the different types of crimes that are involved when we're talking about domestic violence. The very first murder I worked on and the very last murder I worked on were cases in which the person who perpetrated those homicides had previous incidents of violence in the home. This is not a gun bill. This is a domestic violence bill, a victim bill. It's not political, it's not about guns, and it's not partisan. We're talking about people who have been convicted of a crime involving domestic violence. Convicted. I want that to resonate. We're not talking about the accused. We're not talking about mere allegations. We're not at this stage talking about someone entitled to the presumption of innocence with regard to that conviction. We're talking about proof beyond a reasonable doubt that they committed that crime. It's not an early stage of the proceedings. This is after notice, opportunity to be heard, and the most legal process and protection you can imagine. It takes a lot in nature and in number for a victim to even contact the police. It takes a lot for someone to be convicted of a crime involving domestic violence. I've conducted the jury selections. I know the look on prospective jurors' faces when the judge reads that offense of domestic violence. The change in their demeanor is unmistakable. I have heard from the prospective jurors when they say, I'm uncomfortable hearing these allegations, I'm unwilling to weigh in on the judgment of this case. And even prospective jurors who say, I don't think I should be involved in what I see as a private matter. We've come a very long way in the way that we respond to, investigate, report, and prosecute domestic violence crimes. But we still have so many barriers to conviction. So if we're talking about someone who has been convicted of a crime involving domestic violence, they've earned it. That conviction of a crime involving domestic violence is the biggest red flag that we can raise on someone. That is one of, if not the most obvious indicators of violence and risk of future continued violence. And I say again, these are domestic violence bills. Presently, we have a two-tiered system under our prohibited person statute, what we commonly refer to as felon in possession. You have felonies, you have specified felonies. This bill adds a third tier. People convicted of a misdemeanor crime involving domestic violence. Among my responsibilities with the state police, with laws regarding domestic violence, is instructing, I think I said this, instructing all of our recruits on these laws.
And you referenced quite a bit in your testimony the federal law. Is there any difference between this law and the federal law, and if so, what is the difference?
There is. The definition in Senate Bill 471 is more specific. It specifically outlines the statutes and offenses for which this would apply, where there is that intimate partner or domestic relationship.
And that is the only difference, is the definition.
The federal law is also a permanent prohibitor. There's not a time period of the 8 years like there is in Senate Bill 471. So after 8 years following the completion of the sentence under state law, if 471 were passed, then that convicted person's rights to possess would be automatically restored.
Okay, I'll kind of take a look at the differences between the two and maybe get back to you if we have suggestions. Thank you.
Yes, sir. Thank you.
Senator Johnson.
Thank you, Madam Chair. So who under the federal law does have the ability right now, the power to take care of this situation like we're talking about? When you say it's a federal law, then what arm of law enforcement would be able to be involved?
Federal law enforcement officers like the FBI, Department of Justice, but not our state county prosecutors who handle the overwhelming majority of these types of cases. Have more of the local resources to dedicate to them. There's obviously so many more of us enforcing in state police, county, local police departments able to enforce state law.
Thank you.
We have another question from Senator Runstead.
Thank you. I guess we can try to ferret this out, but I was told it was being accused that one of these can cause a CPL suspension, and that under the federal law is not permanent in U.S. versus Stanford, 6th Circuit Court 2015. Do you know if that's accurate?
Can you say
You said that under the suspension is permanent under federal law, but I was told under U.S. versus Stanford in the 6th Circuit Court 2015 that it was not permanent under federal law.
18 U.S.C. 922G is a permanent prohibitor.
Okay, well, I guess we'll
I'm not sure what the, maybe you're talking about a different thing with regard to concealed pistol licenses.
We'll go offline later.
Okay.
Thank you.
Thank you.
Senator Shank.
Thank you. Thank you for telling us about your various areas of expertise. It's pretty incredible that you have all that expertise, and I appreciate that you are bringing it to bear in this area. And I just want to know, excuse me, for my colleagues, that when we back the blue, it's really important to make sure that you have the tools that you need to keep the people of Michigan safe. So I appreciate you working on it and bringing that to our attention.
Thank you. Senator Santana.
Thank you for your testimony. I just want to kind of level set. We're in the process of making a lot of transition with the juvenile justice facilities, and during the last few years, we've codified into law status offenses that judges can no longer utilize that as a way to put kids in detention. And what we're seeing just in the county of Wayne is that judges are using domestic violence as a way to put kids into the JDF facilities. And so I just want to know how this is going to relate to them when it comes to the type of offenses that judges are putting on them, but yet really it does not warrant the type of, the things that they're doing is truancy, maybe having issues at home with, other siblings or what have you. It doesn't arise to the merit of a domestic violence issue. And so I'm just wondering how this relates to them or pertains to them, this
what we're doing today or what the law that we're currently looking at as a potential law?
Sure, I think what you're getting at is maybe some of those reforms that are necessary more in that juvenile justice area. I did not practice juvenile law. I, unfortunately had to respond to incidents like that you're talking about. There are so many tools available and that should be used more, I think, like what you're getting at with juvenile justice.
Again, everybody is on this panel. This committee is in favor of reducing domestic violence, reducing gun violence. And you referenced the objective statistics. And I'm just a statistics guy. It's the way I am on every committee, and I pay a lot of attention to that. So the 98 women were murdered in Wayne County, is that correct?
That's correct.
And did you parse out between those who, there was no evidence, no intersection with the criminal justice system, and then they went out and committed this crime, or they had committed felonies and other things, and then they committed this crime? And we did those out to the specifics where this specific language of this bill would have prevented a specific number of these. Did you parse that out?
No, unfortunately, we do not have that in our system to track it separately that way. We could probably give you simple examples of certain cases, yes, but I don't have those parsed out.
I would presume 98 is not that big a number to go through and say, okay, these guys are felons, these people, there was no interaction, now here's the misdemeanor group, and then here's the specific category. It doesn't seem like it would be a big, giant task, but I'd just be curious to know what that number was. Thank you.
Thank you very much for your work and for your testimony. Up next, we have Heath Lowry from the Michigan Coalition to End Domestic and Sexual Violence.
Good afternoon, distinguished members of the committee. As was stated, my name is Heath Lowry. I'm proud to serve as the staff attorney for the Michigan Coalition to End Domestic and Sexual Violence. It's a nonprofit organization that represents over 70 domestic and sexual violence and human trafficking service providers in every county of this state. And further, in my capacity, I serve as an attorney for survivors of domestic and sexual violence in state and tribal courts across this state. And standing beside survivors, I am borne witness to the panic, the dread that is within the survivor as they worry about what that perpetrator is going to do as soon as they get out after a short stint in jail. Safety planning for that moment had the nearly impossible task of accounting for a perpetrator who has access to an instrument, a weapon that can end the life of that survivor in a flash. This creates a sense of hypervigilance whenever the survivor is in their front yard, taking a break from work, in the parking lot after getting done grocery shopping, or any other everyday place where we are just existing but have been the spots of murders committed against by abusers. I cannot tell you the number of clients I've had that have completely uprooted their life because of this worry. Just because the perpetrator swore to kill them if they ever participated with prosecution, went to the police, or just separated themselves from the relationship. That change is just for a semblance of safety, but it's because they believe the perpetrator. And then that belief is very well founded because convicted abusers have shown to society that they are dangerous people. And the lethality statistics that you've all heard several times here show that that is a firmly held belief and it should be taken into account.
You referenced these individuals who are cooling their heels in jails and prisons. And I think probably those are the exact people I would like cooling their heels in jails and prisons, and would like prohibited by this law to have a gun. Again, as I spelled out before, I think the devil's in the details, making sure we're getting somebody who is an abuser, somebody who's a violent abuser to not have a gun is my goal too. But again, hopefully we can work with the sponsors to ensure that we're not violating the rights, constitutional rights, but also getting these abusers to not have weapons. Thank you.
Yes, and I would reference that the list of offenses within this bill also have another qualifier on top of them that requires that the victim of that case be someone who mixed this crime with domestic violence offense. It's not just a conviction for that particular offense. So there are added layers of protections for that analysis.
Thank you for that clarification, and also thank you for your office as well as the Attorney General's office and the treatment board was really helpful in crafting that very specific language. So appreciate that. Up next we have Angie Popolitis from the Michigan Domestic and Sexual Violence Prevention and Treatment Board.
Good afternoon, Chairwoman Chang, Vice Chair Bunstead, and members of this important committee. My name is Angela Popolitis. I am a former intimate partner violence prosecutor, both in Wayne County and with the Michigan Department of Attorney General. And I'm currently a staff attorney with the Michigan Domestic Sexual Violence Prevention and Treatment Board. Just a bit about the board. We are a legislatively created, governor-appointed, independent board made up of 7 members. And within our enabling legislation, we are tasked with funding domestic violence, sexual assault services throughout the state, but also weighing in on policy, advising and teaching about domestic violence and sexual assault and other intimate partner crimes in our state. And here today on behalf of the board, and the board does support Senate Bills 471 and 472. And we are grateful to Chairwoman Chang for introducing this important legislation. The board also appreciates the opportunity it's been given to work with the sponsor and other stakeholders on crafting these bills. The connection between domestic violence and firearm fatalities is undisputed. You have heard significant statistics and other anecdotal evidence throughout the course of the testimony today. I won't repeat those. But I do think it's important. And again, you've heard it. Firearm in a home makes a domestic violence 5 times more likely to be lethal. We know that as a statistic, but anecdotally, all you have to do is pick up a newspaper in this state almost every day, if not every week. And there is a situation where someone has tried to leave, where they have been found, where they have been murdered. And in fact, what we've seen is that it's not only that victim who is at risk. It can be their children, their family members, their coworkers, anyone else who comes between them and their abuser.
Dr. April Zioli at the University of Michigan.
Hi, I apologize for being on Zoom, but circumstances did not allow me to come in today. But thank you for allowing me to speak today regarding the research evidence on domestic violence, firearms, and firearm policy. I'm the Policy Core Director for the University of Michigan's Institute for Firearm Injury Prevention, and I'm here as a gun policy and domestic violence researcher who has spent the last 20 years of my life focused on determining which gun safety laws are associated with reductions in intimate partner homicide and how best to implement them. We've heard from a lot of people about how when a violent intimate has access to a firearm, a dangerous situation becomes a potentially lethal situation. We know that nationally, since roughly 2014, the number of intimate partner homicides in the United States has been increasing. That's after decades of decline. And that increase is almost exclusively driven by intimate partner homicides committed with guns. Intimate partner homicides with other weapons have stayed at the same level over time. In Michigan, intimate partner homicide counts had steadily decreased from 1976 through the 2000s, and in 2014, non-firearm intimate partner homicides started going down even more, while intimate partner homicide with firearms started increasing. In 2020, 17% of homicides in Michigan with known offenders were intimate partner homicides. 38% of homicides of women were intimate partner homicides, however, and 64% of all intimate partner homicides were committed with guns. Senator Rumstead has asked for an example of how this law would work, and since I'm the one in front of my computer, I found one. There's a case, it's from Alabama, sorry I couldn't easily find one from Michigan, of Paige Mitchell and Bradley Gray. Alabama similar to Michigan, doesn't have this misdemeanor domestic violence conviction firearm restriction law. Bradley Gray had been convicted of misdemeanor domestic violence and was prohibited under federal law from having a firearm. He had his gun confiscated by police at the scene of a domestic violence crime. It was confiscated as evidence, but it was later returned because under Alabama law, they had no reason to keep this gun now that it wasn't needed as evidence. And Gray subsequently shot and killed Paige Mitchell. Had they had that law, they could have kept the gun, he would have been barred from having it, and potentially Paige Mitchell would be alive today. It's therefore critical that intimate partner violent offenders do not have access to a gun. This bill is the first step in ensuring that those convicted of domestic violence misdemeanor crimes don't have access to guns in Michigan. We've heard about the federal law. While the bill under consideration does not explicitly say that this firearm restriction would apply to people who are in the military or work in law enforcement, the federal law does apply to people who are in the military or work in law enforcement or have employment needs to have a gun. I presume that the Michigan restriction would apply to military law enforcement and people with employment needs for a gun, but I would urge the committee to spell that out so that it's clear. State actors, even though we have this federal law, state actors don't enforce federal law, and federal agents are not frequently or consistently employing or enforcing this law. That means while the federal law covers Michigan, Michigan does not prohibit domestic violence offenders from having guns and doesn't ensure that they don't access guns. The state level misdemeanor domestic violence firearm restriction can save lives. However, research suggests that this restriction must be implemented to save lives. It's not enough to pass a law. Research examined the association of state-level firearm restrictions for individuals convicted of these misdemeanor crimes and found that they were associated with lower rates of homicide of pregnant and postpartum women. The majority of pregnant and postpartum women who are killed by their intimate partners, and homicide is the #1 cause of death for pregnant and postpartum women.
Thank you for your testimony, and certainly when it comes to domestic violence, I don't want people committing domestic violence to have guns either. It's very often, it's how the bill is written, it's how those are defined. I was told about somebody who threw their partner's glasses out on the sidewalk, and there were $200 glasses, and in anger, that destruction of that property could have led to a misdemeanor it was a pair of glasses in an argument. But more specifically, so again, that's the devil in the details. More specifically, you talked quite a bit about the intimate partner violence killings, rather, in Michigan. And you've been doing this for 20 years, you've got a big budget, you're the expert. In terms of the statistics, again, I always go back to the statistics when numbers are thrown out, but we haven't parsed them through. Have you taken a look of the intimate partner violence, the killings rather, in Michigan, and parsed out how many would be impacted by this law? In other words, if they've already had a felony, they're not allowed to have a gun. If they committed a felony, they're not allowed to have a gun. If they never committed any of these misdemeanors or anything, they wouldn't have surfaced where the gun would be taken. So the number that would be impacted by the specifics of this law, have you done any research to tell us what that number would be?
I published a study in the journal Homicide Studies in 2021 where I looked at intimate partner homicides in Michigan in, I think it was 2014 and 2015. And I found that 9 individuals that I was able to track the criminal histories of, I wasn't always able to track the criminal histories of these people, had been convicted of a misdemeanor crime of domestic violence and went on to commit homicide.
but without the background, the criminal background, it's a worthless piece of information that could have had a rap sheet a mile long. So again, it would be nice to know.
But, you know, I had full criminal histories for some of the intimate partner homicide offenders. It was that some intimate partner homicide offenders, I wasn't able to get their criminal histories. But for those that I did, I had their full criminal histories, and 9 of them had been convicted of domestic violence misdemeanor crimes.
They would have fallen under this specifics of this bill, and they had no prior criminal history.
It is possible that additional people would have fallen under the specifics of this bill because I only looked at misdemeanor assault.
So we're close to time here, and a couple of us are going to, or we need to get over to another committee starting in 2 minutes. So, and I apologize because I know there was another individual who wished to speak in support and another question, but we will have more testimony. We'll give another opportunity so that we can hear from more folks and get more answers to questions. So thank you. Cards will be in the minutes and we will read them verbally at future hearing. There being no further business, the Senate Committee on Civil Rights, Judiciary, and Public Safety is now adjourned.